Hi guys, welcome to my channel, The Legal Affair with myself, Attorney Bay. As always, we talk all things law, and our conversation today is on property and the legalities of properties. Please, of course, do remember to subscribe to our channel on YouTube, The Legal Affair. You can follow us on social media platforms, The Legal Affair. You can also follow me on TikTok and Twitter at attorney_bay. That's at attorney_bay. So our conversation really on property today is understanding some of the legalities that are involved when it comes to either purchasing property or selling property. We do also talk briefly through some of the fees that are involved when it comes to the property space. Um, and we look at the timelines that relate to property, the involvement or the parties that are involved when it comes to buying or selling property. And we talk about the attorneys and the involvement of attorneys when it comes to purchasing property. So, obviously, when it comes to purchasing or selling property, you will have an offer to purchase or a sale agreement. Essentially, of course, the sale agreement sets out the details of the properties that have been sold, the value the property is being sold at, and a number of terms and conditions that the seller and the purchaser that are involved agree to. Now, an important element also with the sale agreement is that there is often an agent or an estate agent that is involved. In some instances, of course, you'd find that you are able to sell a property without having an agent involved. In an instance where there is an estate agent that is involved, you will note that the estate agent, of course, has a commission that is payable. Now, an important element to bear in mind when it comes to the commission of the agent is that you must always ensure that your offer to purchase or your sale agreement for the property actually reflects what the agent's commission is. In some instances, you'll note that the agent's commission can be a percentage on the basis of the property that's being sold, and in some instances, the agent's commission is actually a flat fee. Just I think it's an important element to just ensure that the sale agreement for the property in question always reflects what the agent's commission is. So don't agree to commission with an agent verbally. Always ensure that the agent's commission is reflected in writing on the sale agreement. Another important element when it comes to the sale of property is the valuation. Now, a valuation is often done by the estate agent if there is an estate agent that is involved. And in some instances, if there's a purchase of a property, you've approached a bank and you've requested a bond, the bank that also grants a purchase of a bond, they do a valuation on the property. I think an important element when it comes to the valuation is trying to ensure that the valuation is a valuation that's recently done. So if a property has been sitting on the property market for a long period of time, always try to ensure that you request an agent to do a valuation of the property before you sign the sale agreement. And in some instances, of course, if there is a bank that is going to grant your bond, the bank will definitely also do a valuation on the property involved. Now, prior to signing a sale agreement, I think it's very important for you to actually inspect the property, have a walk through the property, see what is damaged on the property, so that you are aware if you're a purchaser of a property and you're moving in, you're aware of some of the issues that are there on the property. Now, an important element regarding property, specifically regarding the terms or the clause of an offer to purchase or a sale agreement, are latent and patent defects. Now, latent defects are defects that are not easily seen on a property, and in accordance with the Consumer Protection Act, a seller actually has an obligation to ensure that they disclose the latent defects. So latent defects are defects that can be seen. For instance, if you opt to have an inspection done on the property, in some instances, if you rely on experts to do an inspection on the property. I know there are a lot of companies that offer inspections on property. Of course, the inspection is done at a price. You would find that there are latent defects that you pick up versus patent defects. Now, patent defects are defects that are often easily visible on a property. So, for instance, when you're doing an inspection on the property, you find a cracked window. You're doing an inspection on a property, you find a broken cupboard. So it is always important prior to signing a sale agreement to actually do inspections on a property. And a very important element regarding the terms and conditions of a sale agreement are latent defects. Sellers always have an obligation to ensure that they disclose the latent defects of the property to a purchaser in question. Now, another important term when it comes to property is a footstool clause. So what a footstool clause is it essentially says that you, as a purchaser of a property, when buying the property, are buying the property as is. So if there are any cracks or there's anything broken. But for the latent defects, that the seller actually has an obligation to disclose to you as a purchaser of the property. The incorporation of a footnotes clause in an offer to purchase or a sale agreement means that you as the purchaser of the property are accepting the property with whatever defects that there are, of course bearing in mind that the seller has an obligation to disclose latent and patent defects. So there are quite a number of considerations you want to look through when it comes to the purchase agreement or the sale agreement or the offer to purchase, whichever term you prefer to use. And I think another important element when it comes to the terms and conditions is suspensive condition. So what suspensive conditions are in the contractual space is that they suspend a contract until those conditions are met. So for instance, when you're purchasing property, once you've signed the sale agreement, you'd find that as a purchaser you are given a period of 10 days to ensure that you pay the condition, pay a deposit, for instance. Now, should the 10-day period lapse and you as a purchaser haven't paid that deposit, it means that that sale agreement also lapsed. This is because the suspensive conditions suspend a contract until those conditions are fulfilled. So when it comes to an offer to purchase or a sale agreement, if you put suspensive conditions in a contract, it is also so when it comes to suspensive conditions, really a purchaser and a seller of property must always ensure that they meet the suspensive conditions. And in an instance where, of course, the suspensive conditions aren't met, it would mean that that contract will lapse and it's no longer valid and binding. So some other considerations when it comes to the property process of either buying or selling are the involvement of the attorney. So there are quite a few attorneys that are involved. You've got the bond cancellation attorneys, you've got the bond registration attorneys, and you've got the transferring attorneys. So the bond cancellation attorneys are the attorneys that have the responsibility to cancel the bond over the property. Now, in an instance where a seller of a property had applied for a bond when the seller had purchased the property, there will be bond cancellation attorneys. But in an instance where the seller of a property, when they bought the property, didn't finance the property using a bond and they paid for the purchase in cash, it would mean that in the transfer of property, there won't be a bond cancellation attorneys or bond cancellation attorneys. The bond registration attorneys are involved or are required for purchases. So in an instance where a purchaser purchases property and the purchaser opts to apply for a bond with the bank, there are bond registration attorneys. Now the bond registration attorneys are of course appointed by the bank that finances or opts to grant a purchaser the bond, and the bond registration have the responsibility of registering the bond of the property in the name of the purchaser. There are also transferring attorneys, and the role of the transferring attorneys is to transfer the name of the property from the seller to the purchaser. The transferring attorneys also deal with every other process in between, from transferring the property into the name of the seller, the name of the seller to the name of the purchaser. So the importance of the attorneys is that the bond cancellation attorneys and bond registration attorneys only come into play if either the seller or the purchaser had opted to apply for a bond. In an instance where either the seller or the purchaser didn't apply for a bond, you would find there would be no bond cancellation attorneys and there would be no bond registration attorneys. So the only attorneys that will always be there are the transferring attorneys. The involvement of the bond cancellation attorneys or the bond registration attorneys only comes into play if either the purchaser or the seller had applied for a bond. Another important element when it comes to property and purchasing the property are the fees that are involved. So there are quite a number of fees that both the seller and the purchaser will have to pay in relation to the property process. For the seller, obviously, you're going to be incurring fees to ensure the sale of the property is done, and for the purchaser, there are fees that are involved for acquiring the property. So for the purchaser, an important fee is, of course, the bond that the purchaser will pay on a month-to-month basis. Another important fee for the purchaser is the costs for the transferring attorneys. In other words, the attorneys that are required to transfer the property into the name of the purchaser and remove. So with the transferring attorneys, the transferring attorneys will of course be required to facilitate the transfer from the name of the purchaser, rather from the name of the seller to the name of the purchaser. So purchasers are liable, like I said, for their bond fees. The bond fees is paid on a month-to-month and dependent on the terms and conditions and the number of years that the purchaser had agreed to pay the bond with the bank that facilitated or funded the purchaser with the bond. And of course, the fees also in relation to transferring the property from the name of the purchaser to the seller are the fees of the transferring attorneys. It is, of course, the purchaser that is required to pay those fees, and they facilitate or are required to move or change the name of the seller from the seller rather to the purchaser of the property. Now, when it comes to fees for the seller does incur quite a number of fees. You'd find, for instance, that the seller would incur municipal rates fees. So in the property process, a seller will be required to pay their municipal rates in advance. It's usually about a 3 or a 4 month period. So the seller will be billed for a 4-month period in advance, and in that 4-month period, the transferring attorneys will be attending to the transfer of the property. So in other words, transferring the property from the seller to the purchaser. Now, a seller is always required to pay the municipal rates in advance when it comes to the sale of the property. In turn, what the municipality does is that they will issue a rates clearance certificate. The rates clearance certificate rather, of course, confirms that the seller has paid their rates for a 3 or 4 month period in advance. The rates clearance certificate is confirmation, of course, that that seller for a certain period of time will also has no outstanding rates, municipal rates that is to pay. There is also a levy clearance certificate fee that a seller of a property will incur if the property that is being sold is situated on a body corporate. The body corporate would ordinarily or normally issue a levy clearance certificate similar to the rates clearance certificate. The levy clearance certificate is the seller paying the levies of the property in advance. It's usually about a 3 or a 4 month period, and the transferring attorneys will, of course, try and have the transfer done within that 3 or 4 month period. What the levy clearance certificate does, similar to the municipal rates clearance certificate, is that it confirms that the seller of the property no longer has outstanding levies for that particular body corporate. It is, of course, valid for a certain period of time, and like I said, the transferring attorneys will always try and ensure that the transfer of the property is done within that time frame according to the rates clearance certificate and the levy clearance certificate, or in accordance with the terms and conditions of the offer to purchase that the seller and the purchaser have agreed. Another expense that the seller might incur is a bond cancellation fee. So this is the fee that is payable by the seller to the bond cancellation attorneys. Remember that the bond cancellation attorneys are the attorneys that are required to cancel the bond for the seller. An important element when it comes to bond cancellation fees is that, of course, if there's no bond over the property, so meaning that when the seller had purchased the property, he or she paid cash, there won't be any bond cancellation fees because there aren't any bond cancellation attorneys. Another important consideration when it comes to fees are shortfall fees. So in some instances, a seller may have a shortfall, and the shortfall is often triggered when a seller sells the property at a loss. You'd find that with a shortfall, the seller is required to pay their bond in advance for about a 3 or 4 month period, depending on the calculations done and provided by the bank that granted the seller a bond. The seller would be told what the shortfall is, what the amount is. That shortfall fee would be paid to the transferring attorneys, and that ensures that by the time the bond cancellation attorneys that are responsible to cancel the bond, when they cancel the bond, the seller no longer has an outstanding amount on their bond. So shortfall fees aren't always applicable, but you'd find a shortfall that is applicable in an instance where a seller is selling property at a loss. And perhaps another last or an important fee when it comes to the fees in the property process for sellers is a bridging finance fees, or fees that relate to bridging finance. So there are companies that offer bridging finance, and essentially what the bridging finance is that it's a loan, of course, to the seller, and that loan is given on the basis that the seller has proceeds from the sale of the property. Now the seller can decide how much they would like to loan on the basis of the bridging finance. But an important element is when it comes to bridging finance is that the interest rate for bridging finance is actually quite high. It's usually very higher than what a banks would ordinarily offer. So it is quite important that I think the seller must ensure that they're aware of what the bridging finance amount will be. Obviously, the entity that offers bridging finance will give you an estimation of how much you will owe them when the proceeds are paid out. And the proceeds of the bridging finance are actually the proceeds rather from the sale of the property on paid to the seller first. Any expenses that the transferring attorneys may have incurred on behalf of the seller. So, for instance, if the seller took out bridging finance, those bridging finance fees will be paid before the proceeds of the sale are actually paid to the seller of the property. So it is a very important, if as a seller you'd find yourself requiring finances and you opt to use bridging finance, I think it's very important that you must always request that you are provided a copy of the agreement that relates to bridging finance, and actually look through it to see how much you are going to pay at the time the property registers into the name of the purchaser, meaning that you are no longer regarded as the seller of the property. So, of course, when it comes to the timeline of a property transfer, it can take anything from about a month and a half to about 3 months or 4 months. In some instances, you'd find, of course, there are terms and conditions that are incorporated into the sale agreement, that the purchaser and the seller agree to have the property registered within a certain time frame. So there are a number of considerations that you'd want to bear in mind as a seller of a property or as a purchaser of a property. And of course, there's quite a lot of requirements that are required from the seller and are required also from the purchaser. I think the last thing that really we can chat about are the various certificates that a seller is required to provide. So when you're a seller of property, there may be a gas compliance certificate, there may be an electric compliance certificate, and there may be an electric fence certificate. So if, of course, the property has an electric fence, you as a seller are required to provide an electric fence certificate. This certificate merely says that the electric fence is compliant with the Occupational Health and Safety Act, and of course that it actually works. In some instances, you would find that they incorporate a term, they being the seller and the purchaser, that the seller is not required to provide an electric fence compliance certificate. This is something that does happen. There's no obligation then on the seller to ensure that they provide an electric fence certificate. But if you don't obviously have an electric fence, you won't be required to provide an electric fence certificate. Similar with a gas, if you've got a gas on property, like a gas stove for instance, you may be required to provide a gas compliance certificate. This is just to ensure that the gas on the property is actually compliant with the Occupational Health and Safety Act, and that it is functional. Similar with the electric compliance certificate, the electric compliance certificate is a mandatory certificate, of course, versus the gas compliance certificate and the electric fence certificate, which aren't always mandatory. In some instances, you'd find that they are waived. So the purchaser would say to the seller, "Look, I'm not going to put an obligation on you. The electric compliance certificate. I'm twisting my tongue. The electric compliance certificate is always mandatory. The gas certificate is actually is mandatory. However, in some instances, the purchaser do have a discretion to say or incorporate a term that they don't expect and the seller to provide the certificate. Similarly with the electric fence certificate. So like I said, the property process is quite lengthy, and the requirements and expectations will differ from purchaser to seller. But as always, and like every other contract, prior to signing the contract, as a purchaser and as a seller, go through the contract. Always ensure that any agreement that you have, either as a purchaser or as a seller, or agreement you have with the agent, are always reflected in writing. Try and avoid having agreements verbally, so as to avoid disputes. And should you make any changes to the terms and conditions, also have those changes in writing. Another thing that you can also do, you can add an addendum or an attachment or an annexure to the contract. You can call it addendum 1 or anything really, just to ensure that if there are any changes to the terms and conditions, those changes are always in writing, and try and ensure that every party to the agreement is given a copy of that addendum or annexure or whatever you prefer to call it, just to ensure that you are all in agreement, that you are all have a copy of those revised terms and conditions, so as to avoid disputes. Anyway, thank you for watching today. We hope you enjoyed our episode. Please, of course, do remember to subscribe to our channel, The Legal Affair.